Welcome to the CodeCast podcast. Real-world insights for your daily medical coding and billing processes. And now, here's your host, Terry Fletcher.
Hello, everyone, and welcome to the CodeCast podcast today. My name is Terry Fletcher. I hope everyone had a nice 4th of July holiday. I know I did. My daughter and her husband were here, and it was a really nice time. Spent most of the time in the pool. Actually had a couple of days where I didn't work, which is unlike me. I usually work 24/7, but it was nice to have a couple of days off and just, enjoy family. Okay, so what is my topic today? Well, I came across something in Part B News, which I thought was interesting, and I wanted to share it with you because I actually took issue with some of it, and then I was looking in some of the different states to make sure I could verify some of the information, and some of it was true and some of it was not accurate, I guess I'll say. And so we just want to make sure we understand when we're talking about HIPAA. So obviously you have to keep HIPAA compliance in the front of your mind when a patient asks you to send their records anywhere. In particular, your practice needs to understand what you should do or shouldn't do when it comes to getting authorization from the patient to disclose protected health information in response to an employment-related request. So what that means is that the patient is on workers' compensation, and that's how they're being seen in your office. So it's a little bit different than just, I hate to call it a regular patient, but pretty much a regular patient where their employer-sponsored insurance is paying, where typically they have to pay some of that premium, or they have their own insurance, or they have government-sponsored insurance. So under those HIPAA rules, the patient actually has a lot more rights when it comes to complying with requests for patient information. So it has to be authorized. The patient has to sign something that says it's okay, or their appointed representative. But the HHS was trying to explain that, in addition, state workers' compensation laws might require a provider to submit, patient health information, and the employer will eventually see that information. But what is your responsibility as a practice to make sure that you are what we like to call following the minimum necessary rule and only sending the information necessary to perform the specific tasks when it comes to employment-related requests? So what I mean by that is, remember, the employer is paying the bills when it comes to workers' compensation. Patient hurt themselves at work in whatever state they're in, then that employer is entitled to that information. Well, let me kind of back up a little bit, sort of. And what does the provider have to disclose to meet that minimum requirement that the provider, or I should say the employer, is privy to? So, the provider should only disclose the PHI required to comply with the patient's authorization to disclose such protected health information to the employer. But let's face it, if the employer doesn't get what they want, they're not going to pay the bill. So the provider should not send information that is outside of what the patient authorized. That's the key. So including any information that is outside the date range as well. So, for example, if a patient hurt their shoulder and that now under workers' compensation, and the patient's getting E&M visits, they're getting surgery, maybe even physical therapy, and the employer wants to see what's going on to see, when the patient's going back to work, how much the patient has recovered, and just really understand the medical situation of the patient. Anything related to that work comp injury, the employer is entitled to. If the patient says, well, I don't want him to have anything, they're going to have a problem. Now, let's say that this shoulder patient also had HIV, or they had depression, or something that was outside what they are covered for under their workers' compensation. The employer is not entitled to that. Now let's look at a different patient. Let's say employment-related screening, like drug screening, return to work exams, or disability determinations. So in these circumstances, HHS has an opinion that the employer does not have a right to the employee-patient PHI So the patient would need to specifically consent to the provider sending this information to the employer. However, even if the practice needs to get the written consigned consent form from the patient that spells out exactly the information, the practice needs to work quickly because the patient's terms of employment could require the information in a timely manner, and let the patient know that. They need to know, you may have some, I don't want to call it liberties, but some protections here, let's call it that. But if the employer wants something that says you can't work until we see what your drug screening was, or your physical work exam to be cleared, and you're saying no, they can't have it, well, now you're in a pickle because that could be a problem in terms of your employment and keeping that information a secret. Then they're going to suspect. It's, in my opinion, it's like, taking the fifth. It's like, well, I'm not going to answer that question. Well, then we don't have to pay you and you could be let go from your position. So also you need to check with your state. We have some really weird things here in California with regard to that, where the workers' compensation Department of Work Comp is entitled to almost everything except anything that falls outside the scope of what they're actually being seen for from a work comp perspective. So HIPAA permits providers to comply with each state workers' compensation laws, including providing PHI to the state workers' compensation program upon request. So the patient's employer is eventually going to see that PHI disclosed in response to these disclosure. If you are at all wondering if you can't find it for your state, you might need to consult with an attorney to determine whether the relevant state requires the practice to respond or permits it to respond to the request. Most states do require a provider to send put such information to the workers' compensation program upon receiving the request. Others may have what they may permit the provider to send such PHI. There are states where the laws permit the provider to send PHI and the provider can choose not to. So look at the language. Is it require? Is it mandated? Is it permitted? And so, it would be uncommon for an employer to contact the provider directly for PHI for the employee. It's usually third party, so it is whatever, the workers' compensation insurance plan that's covering it, unless it's a self-insured employer. But if it happens and you have, that request, first of all, reach out to the patient. Say your employer wants your, health information, and make them sign a request, and a consent, I should say, because you want to make sure that they understand that first of all, is the request authentic? And is it confirmed that it is part of what the employer wants? It's not just coming from somebody who's fishing, which does happen. So be careful about that. If it's a third-party company that is not the employer's insurance company, then be careful, because they wouldn't be subject to get that information unless the patient and the employer requested it directly. But you really need to look at every case as a specific case. In all cases, attention should be given to ensuring that the written request, again, is authentic, that it is something that the patient understands that could come back on them. And then also keep in mind two more pieces of guidance when you receive these employment-related PHI requests. You can charge the patient for sending the records. HIPAA allows you to charge the patient or the payer, whoever requests it, reasonable costs associated with copying and sending the records. I know in California it's $35. But you can't charge the patient for the time it takes you to find and retrieve the records, which I find interesting. And in addition, certain state laws may create additional requirements. Like some states like Ohio, they have regulations on fee calculations that providers may charge. I know Texas has the same thing with TWIC. Again, I always come back to my state, California, and then Florida. They are strange because they allow for PHI and anything surrounding it if the employer requests it. They really, I think it's more to deter unfounded claims of workers' compensation. And so, but start with the HHS Office for Civil Rights FAQs, because HIPAA privacy rule doesn't include specific guidance on employment-related requests, so I had to find it for you. But the OCR has created searchable FAQs that can answer certain basic questions. They always seem to go back to also you should consult an attorney. That's your last resort. Really do some due diligence. I know if you're a member for my coding corner, we do that for you. So if you're dealing with that, just join our membership. But if you're not, and you're a podcast listener and you're trying to figure out, we get those requests and we didn't know if we have to send, if we have to make sure that the patient has authorized it first or what. Make sure you look at your state. It's usually under the Business and Professions Code, and it usually is also under your state workers' compensation insurance fund. And you can just find that, Google it, and they will tell you, California Department of Labor, Texas Workers' Compensation Company. Just really make sure you're looking. It's called TWCC. I don't remember the exact acronym, but find it on your state, and then you can really figure out what you have to do there. But it's really important to make sure that you follow the rules appropriately for your state and then for the employer, and then that the patient understands. And I would also educate your front office staff, your billing staff, and your back office staff, letting the patient know, okay, now you're under workers' comp. So just so you know, you're a different kind of patient than someone who would have full protections under HIPAA, because the employer is entitled to that information. You just have to know how, what and where you're supposed to give that to them. Okay, the CodeCast podcast is also brought to you today by Decision Health. Struggling to find specialty-specific code training? Decision Health is offering live virtual summits on anesthesia, orthopedic, and pain management coding, as well as billing and compliance. CodeCast listeners can save 10% by entering virtual S2025 at checkout. Register now at decisionhealth.com/virtuals. Okay, so again, I hope everyone had a good 4th. I hope you're not melting too much in this heat. Actually, it's kind of funny, where I'm in Southern California, a little bit inland, and my daughter, when she came out, she goes, oh my gosh, it's so nice and cool here, because she moved to Arizona in 2020, and now she's there with her husband. And it was 108 when she left Arizona, and she came to where we are, and it was 92, and she thought it was cool. Yeah, definitely a little different. Also, I wanted to extend my sincere condolences. I'm heartsick about the flash flood in Texas and some of the lives that were lost and the children. It made me so sad. Really prayers to the families. I know this is going to be just a terrible time for you. And I just hope that, you have some faith there that you can get through it with the support of your family. I know it's a state of emergency, but again, our heartfelt prayers go out to you, and I really hope that they find even more survivors there. So I'm so sorry about what happened there. Okay, everyone, I hope you have a good rest of your week. Make it a great day, and thank you for listening to the CodeCast podcast.
For more information on medical coding, billing, auditing, and compliance, including how to hire Terry, follow Terry on Twitter at TerryCoder1, or visit her website at www.terryfletcher.net. Podcast producer Joe Kuzma. Music producer Dassassin Music.